Hello, ma'am. Good evening.
Hi, good evening. How are you doing?
Shall we start?
Hmm, some connection issues.
Yeah.
Very good afternoon to everyone present here. It's my pleasure to be the moderator for the session. And I'm Gargi, and on behalf of the NUG's ILSA chapter, I welcome everyone in this enriching session on challenges in criminalization in
Gargi, your voice is breaking. Yeah.
criminal law. Speaker Phillips. She is a qualified attorney in New York. Can you hear me, sir?
Yeah, now it's fine.
Okay. So she is a qualified attorney in the state of New York, and she holds a Juris Doctor cum laude from Vermont Law School, Master of Laws in Environment from McGill University, and Bachelor of Arts in International Affairs from the University of Colorado. She is currently a PhD scholar in the International Development Studies program at Chulalongkorn University, Thailand. She is a consultant and doctoral fellow in sustainability and environmental politics in the Stockholm Environment Institute, where she undertakes research related to climate litigation and mineral resource development issues. In addition to it, she is also a lecturer in Sara University, where she teaches international sustainability course. So a warm welcome to you, ma'am, and we are obliged to have you here. And next, I would like you, sir, to give a brief introduction to the topic, and after that, we can proceed with ma'am's presentation.
Okay, I hope I'm audible to all. Yeah. Firstly, I would like to thank profoundly Sara K. Phillips for consulting to deliver the Hillside talk. And in the past, we have hosted some distinguished scholars, including members from the International Law Commission. So I would like to firstly thank Sara K. Phillips for consenting to deliver this talk. So before I mean, handing over the floor to Sara K. Phillips, I would like to give an opening remark as to what topic that we will be discussing today. So we are discussing a very important topic on ecocide. Ecocide is important because in last year or this year, in the earlier this year, the independent expert panelist had proposed a definition of ecocide to be incorporated into International Criminal Code, that is the Rome Statute. Now the question is whether there is the ecocide alongside crimes against humanity, war crimes, or genocide, whether it can be introduced in the Rome Statute. This is something that has been the debate has been ongoing for the past 5-6 months, and there has been a lot of seminar, conferences, writings on this specific issue. Now, if one looks into the history of ecocide, it started the entire positivist international law history started in the 1970s with the Vietnam War, where for the first time a professor, British biologist by the name Arthur Gladstone, coined this term ecocide. And subsequently, there were multiple international conventions on humanitarian law and international criminal law like the NMOD Convention and the IHL Additional Protocol 1, which attempted to articulate on what we call as environmental crimes. But but ecocide as a crime did not find a place in the Rome Statute because of unknown reasons. Although in the initial draft of the ICC, there were discussions and debates on introducing ecocide as a fifth crime. Unfortunately, the crime did not find a place in the Rome Statute. Now, there are two scholars or two sides to it. On the one hand, you have a school of thought which says that ecocide has to be a crime or it has to be criminalized. On the other side, you have scholars saying that no, ecocide will not be finding a place in the Rome Statute because of various reasons, some of which include you have the adequate domestic laws which might cover the issue of involving ecocide. The other reason could be the ICC is already overcrowded. That is, the International Criminal Court is already overcrowded with pending cases. So what's the point of introducing one more crime in a system which is already overcrowded? And there are also scholars who argue that ecocide there has to be a separate convention for ecocide in terms of fixing state responsibility rather than seeing it from an individual criminal liability point of view. So having said this, what we need to remember or keep at the back of our mind is that environment is extinct. The extinction of environment is 1,000 times than what we have witnessed in the past, and there has to be a clarion call or need for the laws to catch up with this. With the laws of environment, we need to be very proactive in introducing laws so that we are in a position to protect the environment. So with this brief introduction to throw light and to provide a detailed understanding on the concept of ecocide, today we have in our midst Sara K. Phillips, who would be providing us with her insights and her inputs on this particular topic. It is interesting how I contacted her. I happened to read one of her works in one of the leading blogs in international relations. So that prompted me to contact her, and that is how we got in touch with each other. And I thought she would be the right person to address all of you on this very, very critical topic that is being discussed in the European Parliament, that is being discussed amongst NGO scholars, etc., etc. So with this, I hand it over to Sara K. Phillips, and over to you, ma'am. Thank you.
Thank you so much. Can you hear me okay?
Yeah, you're perfectly audible, ma'am.
Okay, great. Just let me know if I drop out at any time. Thank you so much, Professor Alexander, for that really wonderful introduction, and to Gargi and Mehul Jain and the West Bengal National University of Juridical Sciences chapter of the International Law Students Association for inviting me to give this talk. I am so pleased to have this opportunity, and I look forward to what I hope will be an engaging discussion following my remarks. So, as Professor Alexander noted, and before beginning the lecture, I would like to note that the basis for this discussion is a perspective piece I wrote for the Stockholm Environment Institute in July of 2021. And in that piece, I provided a few thoughts and critiques on the then newly announced definition of ecocide that was created by jurists of the Stop Ecocide Foundation with the intention of amending the Rome Statute to include a fifth crime. So I'll be drawing directly from my perspective piece in this lecture. And I've also decided to forego the use of a PowerPoint presentation, so this discussion will be strictly lecture-based, without the use of visual aids. But I'm really happy to share the written lecture later on for anyone who might be interested in reading it in written form. So I'd like to begin with a general framing for our discussion. And what I mean by that is essentially, through what lens am I analyzing the issues I will address regarding ecocide within international criminal law? And that lens is structural inequality. So I'm sure that many of you are at least familiar with the term structural inequality, but for clarity's sake, let me briefly describe what I'm talking about. So structural inequality refers to those conditions of inequality and unfairness that are reproduced through systems of law, regulation, and through policies and practices. So these structures create systems that disadvantage, discriminate against, or cause adverse consequences to a particular group based on race, gender, cultural differences, socioeconomic status, or intersections of two or more of these aspects, etc. In this lecture, we are primarily talking about structural conditions that are institutional in nature, observable in international relations, and also in an international development context. Now, why is this important for the lecture? Well, first, I would say that recognition of structural inequality is exceedingly important for any discussion of law, justice, and equity in an international or national context, but especially so when we discuss issues concerning international development and criminalization. I would put forth that any perpetuation of criminal law and the criminal justice system at any institutional level should be met with a healthy dose of skepticism and should be subject to an overall critique and evaluation of the functioning of the structure that such systems are operating in themselves. So as I proceed through this lecture, I would ask you to keep these ideas in mind when we discuss the crime of ecocide. I would also ask you to consider that there really isn't one singular solution, excuse me, to the environmental and climate issues we discuss here. My critiques of a certain approach do not mean that such an approach is meaningless. On the contrary, critical analysis is part and parcel of our work as academics and jurists, and it is my hope that these discussions can work to catalyze meaningful and long-term solutions to some of the environmental issues we currently face. I also hope that through these types of discussions, we can work towards building recognition of those aspects of the structures and systems within which we work that require reform and additional scrutiny. So what is happening in the world? A climate catastrophe, the effects of which are not and will not be felt equally throughout the globe. Please excuse the background noise. Climate-related extreme weather events disproportionately impact and burden the most climate-vulnerable nations and those populations already disadvantaged by existing systemic inequalities. This is especially true amongst the world's poor and most vulnerable groups, who are at greater risk for loss of life, income, and livelihoods, with significantly decreased capacity to cope with and recover from climate-related events. In December 2019, a written statement by Maldives Member of Parliament Ahmed Salim implored state parties to the International Criminal Court, or ICC, to recognize climate victims as part and parcel of the international criminal justice system. Mr. Salim explained that even as countries like the Maldives were in a race against time to prevent a climate catastrophe, there remained a milieu of indifference and climate inaction on the part of the world's largest emitting countries. The time is ripe, he stated, to consider an amendment to the Rome Statute that would criminalize acts that amount to ecocide. It is against this backdrop and what has been characterized as the failure of treaties, agreements, and civil lawsuits to prevent large-scale damage to ecosystems that the move towards criminalizing ecocide was resurrected decades after its original use in the 1970s. And as Professor Alexander stated at the beginning of the lecture, as early as the year 1970, the term ecocide was used to describe the overwhelming destruction wrought by the United States government's use of Agent Orange during the years-long war in Vietnam. The chemical was used to defoliate and kill vegetation and cause long-term irreversible damage to plant, animal, and human life. Decades later, in 2010, the call for an international prohibition on ecocide was taken up by the late Polly Higgins, a United Kingdom-based lawyer whose work is credited for laying the foundation for the Stop Ecocide Foundation's 2021 definition. On June 22nd of this year, the announcement of a new legal definition for the term ecocide swept global headlines. As alluded to previously, a panel of independent experts commissioned by the Stop Ecocide Foundation had created the definition with the aim of establishing a new prosecutable crime under the Rome Statute, and thus within the jurisdictional mandate of the International Criminal Court. The conclusion of the panel's work was praised as a historic moment and conferred other such accolades within the global news headlines. But amid the praise and luster of this newly revealed definition, critical questions arise. Some of these questions have been grappled with before, and many remain unanswered. Perhaps most poignant at the dawn of this born anew definition is how the crime of ecocide would and should be prosecuted in practice. and if this practice would be harmonious with the spirit in which the legal definition was drafted, in other words, the intent of the law. For context, let us read the definition of ecocide here. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. The authors define wanton as reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. Since the June 22nd announcement, scholars and news outlets have prepared an array of relevant and insightful commentary contemplating the challenges and potential of amending the Rome Statute to include a fifth crime. Such analyses have critiqued the definition for its purported ecocentric ideals, while still adopting caveats that amount to a cost-benefit approach rooted to anthropocentric understandings of development. As Professor Heller puts it, it's fine to cause severe and widespread or long-term damage to the environment, as long as humans benefit enough from the destruction. And herein lies what I would posit could be the dangerous subjectivity of the crime. Who shall the international community task with deciding the wantonness of an act of development, and should such a decision fall within the purview of the ICC? The ICC is a self-described court of last resort. Its purpose is not to act in lieu of national justice systems, but to complement them. When envisioning the potential of adding a fifth crime of ecocide to the Rome Statute, it is difficult to foresee how such a crime would have the intended effect that its promoters desire. But beyond these somewhat technical critiques, it is also worth delving further into questions about the function of the ICC as an institution, including a deliberation of what it would actually mean, for example, morally or consequentially, to prosecute individual actors for the crime of ecocide. If the Rome Statute is successfully amended, ecocide would take its place next to such offenses as genocide, crimes against humanity, war crimes, and the crime of aggression. Crimes described as being the most serious crimes of concern to the international community as a whole. Although climate change and environmental destruction are, on their face, grave existential issues, as a matter of law, determining what individuals should be held criminally accountable and subject to prosecution under the ICC would not be unambiguous. Indeed, matters of liability have long been contemplated in the sphere of climate litigation generally. In 2009, a United Nations report on the relationship between climate change and human rights explained that it is virtually impossible to disentangle the complex causal relationships linking historical greenhouse gas emissions of a particular country with a specific climate change-related effect. Perhaps most striking and, in my own view, unsettling to the discussions around the criminalization of ecocide is the general acceptance that allocating individual responsibility for an international crime of this nature could be viewed optimistically as a method to prevent and deter future environmental damage. As jurist Kai Ambos notes, this desired change of consciousness pursued through the use of criminal law is not supported by empirical data, which in fact points to a less hopeful direction. One need only look to the American criminal justice system for an example of what Ambos refers to. It is a system of mass incarceration where harsher sentencing, resulting in the incarceration of more people than any other country in the world, has had little deterrent effect on crime and has and continues to disproportionately impact racial minorities. In a 2018 report to the United Nations, the Sentencing Project, a United States-based research and advocacy organization, explained that at the end of 2015, over 6.7 million individuals were in the correctional system in the United States. That is over 2% of the population. At the time of the report, Black Americans were almost 6 times as likely to be incarcerated as compared to white Americans. Statistically, 1 of every 3 Black male children in the United States can expect to go to prison in their lifetime. As the Sentencing Project report illustrates, disparities in incarceration rates are more than a matter of explicit racial discrimination, but are reflective of deep structural inequalities within the criminal justice system itself. These inequalities are demonstrative of a system that, while based on ideals of formal equality before the law, in practice perpetuates and reinforces disparities among individuals based on race and socioeconomic status. This perpetuation of inequality through the use of criminal law, the report authors asserted, constitutes a violation of the International Covenant on Civil and Political Rights, as well as other international agreements. But you may ask, why is it important to discuss the American experience in the context of criminalizing ecocide? First, support for the proposed crime of ecocide overlooks or willfully ignores the ongoing criticisms of the International Criminal Court that center around racial injustice and structural inequality. I draw upon the contemplations of Randall DeFalco and Frederick McGray, in which the authors contemplate structural inequalities based on race in the United States context for comparative analysis within international criminal justice. In contemplating the ICC's relationship to structural forms of racism, DeFalco and McGray observe that the court has been relatively antagonistic towards criticisms of this nature. As the authors note, the question here is not merely one of whether the ICC is a deliberately racist institution, but rather how the, quote, systemic, pervasive, often obscure perpetuation of racially based inequalities through the totality of society and its institutions has impacted the prosecution of international criminal justice. Law, the authors explain, often plays a crucial role in carrying some of the prejudices of one era forward into another, not least in international law that sees broad fidelity to its past as a validation of its pedigree. The resistance of international legal actors to confront structural criticisms should cause alarm for any who support adding new crimes to the ICC's purview. As Theodore Johnson notes in his article on punitive excess and race in America, to establish a fair and unbiased justice system, we must reckon with the central role race plays in systemic outcomes. Indeed, of the 46 indictments issued by the International Criminal Court, all defendants have been Black and/or Arab Africans. As Kamari Maxine Clark explains, proponents of international tribunals tend to position their work as being about mitigating and prosecuting the effects of violence. Race is coded as being external to an international criminal law paradigm in which all lives are supposed to matter. The cultures and systems of white supremacy are rarely acknowledged as shaping the conditions of injustice, both within and outside this framework. As exemplary of these points, Maxine Clark describes the process through which the substantive crimes of the Rome Statute, or those crimes characterized as the most serious crimes of concern to the international community as a whole, overlap racialized categories in a range of ways, and are the result of what Clark characterizes as brute political negotiation. Maxine Clark points out that along the way, such crimes as colonial domination, apartheid, and environmental damage were simply dropped from the international criminal law purview. This would support the argument made by DeFalco and McGray, in which the authors state that the ICC may be more guilty of racializing as opposed to being racist, in that the court is part of the ongoing social construction of race. There are 123 state parties to the Rome Statute. Among others, this number does not include the United States, China, or India, 3 of the world's largest contributors to greenhouse gas emissions and home to some of the largest multinational corporations. This means that unless the alleged crime here of ecocide occurred in the territory of a member state, the ICC's jurisdiction only extends to those states willing to submit to the court's jurisdiction, or if the United Nations Security Council refers the case to the Office of the Prosecutor. This brings us to our second point as to why the American criminal justice experience is relevant to a discussion of ecocide and the ICC. This point centers on the United Nations Security Council's powers of referral and deferral in the Rome Statute. In his article on the ICC and power politics, Nico Edwards elucidates that such powers have been the subject of significant criticism since the Rome Statute's coming into force in 2002. Edwards explains that while not a party to the Rome Statute, the United States seemingly wields significant influence over the ICC's activities. It bears mentioning here that although international legal institutions such as the ICC proclaim to operate unfettered by the pressures of international politics, the court, indeed the notion of global justice itself, is in many ways a creature of its creators, states. And while the notion of an international court to try individuals for the world's most egregious crimes may, in principle, sound like the pursuit of justice, the dispensing of such justice has not been even-handed and without political manipulation. As Edwards points out, this manipulation has come in many forms, including from African states with interests that are tied to more powerful state actors, such as the United States. Indeed, the way in which the court navigates and acts as an instrument of international politics has been on full display in its decision surrounding an investigation into the situation in Afghanistan. In a pre-trial chamber decision dated April 12, 2019, the ICC ruled that an investigation into the situation in Afghanistan would not serve the interests of justice, in part because the prospect of such an investigation would prove extremely difficult to undertake, and there remained a lack of cooperation by existing authorities. Though the pre-trial chamber's decision was reversed by the appeals chamber on March 5, 2020, a recent statement by ICC prosecutor Karim Khan indicates that while the Office of the Prosecutor intends to resume its investigation, it has narrowed the scope to only those crimes allegedly committed by the Taliban and the Islamic State, and will deprioritize other aspects of the investigation. In addition to the complications facing the ICC in terms of how to best proceed with such an investigation in the midst of a precarious political situation on the ground in Afghanistan and a lack of clarity on the country's leadership, the court faces allegations of Western bias. Such has been the failure of the court, argues Edwards, to resist critics that assert the court is, in essence, a neo-colonial institution. It is certainly not an enviable position that Mr. Khan finds himself in, but the decision with how to proceed with the Afghanistan investigation highlights the limitations of notions of global justice in the context of international relations. As we turn back to the proposed crime of ecocide in light of our discussion thus far, there are a few additional points that bear mentioning. The first is that the ICC only has jurisdiction over natural persons. Allocation of responsibility for an act amounting to ecocide must thus be assigned to an individual or individuals. In this case, those persons working for a company, such as a chief executive officer. A corporation itself cannot stand before the court as it is a juristic, not natural person. This begs the question of what corporate officers might be held accountable for the alleged crime of ecocide, and whether such individuals should become criminally liable for the various levels of decision-making entailed with an activity that might otherwise be legal. Remember, the current definition of ecocide states that an act need be either unlawful or wanton, not both. Second, the ICC is also restrained by temporal limitations, meaning the court only has jurisdiction over those crimes committed after the Rome Statute entered into force in 2002. Even if the remaining outlier states were to become parties to the statute, jurisdiction would only extend to the date of entry into force for that state. Within this temporal category, we can also place the duration of criminal investigations, which even at the national level can go on for years. Such obstacles greatly detract from the notion of ecocide as a deterrent to environmental damage, even in the long term. The legitimacy of international institutions as effective and equitable tools to address global challenges is frequently in question. In the context of international criminal law, some authors have described a pattern of using global legal institutions, such as the International Criminal Court, to continuously persecute and demonize the global South. As the proposal to add a fifth crime to the Rome Statute is celebrated, we should simultaneously question the systemic structural issues that continue to hinder inclusive, equitable development and taint the perceived fairness of international law. As long as such issues go unaddressed, we risk a gradual decline in the fabric and legitimacy of the law itself. This does not mean that all is lost or that international law and legal institutions do not have a valuable role to play in the struggle to protect the environment from increased destruction. Quite the contrary. But we must be increasingly introspective and mindful of the criticisms of these structures and institutions, especially in light of the move towards greater criminalization. The crime of ecocide is inherently related to development activities, such as natural resource extraction and energy development. These activities frequently and disproportionately affect indigenous peoples and the world's most vulnerable populations. Decision-making surrounding such development is often opaque and lacks inclusivity. Moreover, similar dynamics that mar the ICC's mandate also play out on the national level, where communities impacted by development and climate change often lack the resources and capacity to effectively contest activities that harm their surrounding environments, resources, livelihoods, and health. It is often said that criticism is a far simpler endeavor than offering constructive alternative solutions to a problem. One could make this argument as concerns the efforts of proponents of the crime of ecocide. After all, are they not taking action? We have felt the frustrations of combating climate change on a global scale and often watch somewhat helplessly as the environment around us continues to degrade. And sectors such as mining that are of critical importance to clean energy transitions are the sites of increased conflict and tension, which is only expected to worsen as mining projects proliferate. We as jurists are seeing new and innovative legal measures to combat these environmental and human rights impacts. Movements surrounding the rights of nature have taken a hold in many jurisdictions and continue to grow. As Molly Lipson, a prison abolitionist, expounds, criminalization should be seen as conceptually anathema to these efforts and the objectives of climate justice advocates. These objectives, Lipson explains, should focus on reducing the conditions that lead to harm from the outset. Prisons being inextricably linked to an oppressive state apparatus that, in many nations, perpetuates ingrained structural inequalities, thus functions to reproduce those systems that have wrought havoc on our climate and environment. If we consider Lipson's comments in the context of the crime of ecocide, whether it be promulgated at the international or national levels, it reveals itself as being characteristic of a system that refuses to address its inherent inequalities and structural deficits, while desperately seeking to combat some of the world's most pressing and devastating issues. As philosopher Catherine Larrière explains, criminal law condemns only extremes, whereas we should address the basic functioning of a system based on continued exploitation of natural resources. Is such an endeavor more difficult than the perpetuation of an existing criminal justice system? Perhaps. But such a reckoning with the systems in which we operate is desperately necessary if humanity is to achieve the long-lasting and substantiated change needed to address the existential crisis of a changing climate. One of the first steps in this process needs to be recognition. Recognition of structural inequalities that exist at the institutional level and thrive in various forms. Such recognition should be coupled with broad-based policy and legal reforms that are inclusive, responsive, and accessible. As the Arctic Center at the University of Lapland states, such policies should provide each group in the society with means to claim their rights, the opportunity for upward mobility, and the ability to participate in sustainable development. This involves the transformation of subjects and beneficiaries into citizens with rights and responsibilities. The unequal structures that can be demolished by creating equitable opportunities for all groups in the society and social justice. These concepts should not seem altruistic, but realistic. They should be considered tangible, practical goals for policymakers, and their promulgation is long overdue. Should these goals be pursued in tandem with efforts such as the crime of ecocide? Perhaps. But the risk we take then is to muddle the objectives of each of these pursuits. Does the criminalization of ecocide at the international level support the movement to address institutional structural inequalities? If the answer is no, then we must ask ourselves, does it in fact detract from these reform efforts? These are questions, and many more like them, that should be answered if we are to support the expansion and powers of existing institutions. I would advocate that as academics and jurists, we should be supporting individuals and communities in asking and answering these questions. We have the tools and training to significantly shape some of the international and national institutions that are exceedingly important to these changes. Such an endeavor is not easy, nor can it be accomplished by a select few, but it is all the more necessary as we grapple with the current and impending climate crisis. Thank you.
Right. So I'd like to thank ma'am for such an enlightening address. So if anyone has any questions, you can just type them in the chat box. Arunav, can you type a question in the chat box, please?
No, if he wants to ask, he could.
Okay, fine. So actually, I'll give him the co-host controls, then he can unmute and ask. Just a second.
Yeah.
Yeah, thank you so much for the lecture. I wanted to ask a question about the ICC only having jurisdiction over natural persons and what that means for climate justice as a whole. Given that we live in a time where we've seen multinational corporations like Chevron acting against lawyers like Steven Donziger, who won a lawsuit against them in the domestic capacity with certain allegations of corruption and also basic procedural justice being misused to make sure that Donziger is made an example of what not to do and what accountability to not take. What does that mean for the field of international law as a whole?
Thanks for your question. It's a very complicated one. I'm not sure I can answer it to your satisfaction, but what comes to mind is that there's two aspects of the ICC only having jurisdiction over natural persons. And one is that in a positive way, it can do what the law refers to as like piercing the corporate veil, where you can go after individuals within a company that maybe are responsible for direct decision making that result in the environmental crime that would meet the definition of ecocide. On the other hand, I see that as kind of a slippery slope, just thinking about it in general terms as to who exactly would be held responsible, because sometimes it's clear, but in other times, you could be talking about here's just a hypothetical, a multinational company that has a subsidiary entity in a certain jurisdiction, and that is where the crime of ecocide occurs, and then the person who's operating the subsidiary is a national of that country, probably a developing nation, and then that person ends up being prosecuted for the crime of ecocide. There's a lot of different potentialities, and I through the lecture was trying to highlight that one of the things, I guess, that is a red flag for me was just how the court has operated thus far, and why there would be an expectation that there would be different defendants appearing before the court with the crime of ecocide, because so far it's been a very specific group of people that have been prosecuted through the court, and I'm not sure that we could expect to see much change. I don't know what the basis for that expectation would be.
Okay. I think he has a follow-up. Arnav?
Thank you so much for the answer. I do not have a follow-up. I have another question. Is that okay?
Yeah.
Okay. About 5 days ago, I think you might have heard of the Blockade Australia movement, where a bunch of environmentalists are stopping access to one of the ports in Australia that takes in a lot of coal. And the environmental minister of the said country has basically asked prosecutors to throw the book at them, meaning that the individual protesters could face about 5 to 25 years of sentencing in jail for basically protesting against coal being imported into their country. So we have in international law to protect such actors who seek to protect the environment.
You're asking very good questions, and I think, you know, with situations like that, I mean, generally defendants will be subject to national laws, and while international laws might have some persuasive authority, in fundamentally those environmental activists are the subject of the Australian laws where the activity occurred. But I think this kind of maybe I can draw a connection here to the idea of power and structural inequalities, in that you see something like this. I'm not too familiar with the situation that you were explaining. I haven't heard too much about it, but I think you can see power disparities in the way that the industry and government are perhaps pursuing action against individual citizens who are protesting environmental issues. And I think that is kind of at the heart of what I'm trying to discuss here, is that exists at so many different levels, not just internationally, but nationally. It's like an institutionalized inequality, and then we are faced with these power differentials that are sometimes overwhelming. And so while in certain situations people can mobilize and can mobilize resources that can actually sometimes even out those power differentials, the starting point is so unevenly matched that it's often the case that these relationships just are perpetuated forward because these structural issues are not addressed. You know, fundamentally in that situation, and I'm not too familiar with Australian domestic law, but I would just imagine that, you know, obviously the government is supporting the industry in this. And I'm not sure what specific causes of action individuals would have against like the coal industry. I would think that it would be your general environmental causes of action, but I'm not sure how Australia has incorporated like human rights laws into their domestic framework. But my guess is, again, there's still quite a large disparity in what people are able to do versus the power, the financial and legal power that is behind like industry, and especially if they're backed by the state. So as far as coming back to your question about international law, a long time ago, somebody told me that the most power we have is actually at the national level. And the international law is, yes, it's a persuasive and useful instrument, but in general, enacting change has to happen domestically. And then those domestic reforms can inform, state behavior on the international level. And it's just by virtue of like who the actors are at these different levels.
Thank you so much for that answer.
Thanks.
Thank you so much. I had a question with regard to ecocide in general, which I came across while reading several articles, this being regarding international law. So ecocide, the term ecocide is perceived differently in different regimes. So in international humanitarian law, it is seen as an environmental crime to attack the environment using weapons under Additional Protocol 1, Article 3536. On the other hand, there is also a regime in international environmental law wherein you have multiple UNGA resolutions and environmental law granting protection. So my question is, if we conceptualize the introduction of ecocide into international criminal law, will it not create a fragmented regime, right? Whether we are talking about a fragmented regime, which would mean that the enforcement would be a tad difficult because you have an existing system in play. When you're creating a new regime in terms of international criminal law vis-a-vis environment, will it not lead to a situation of regime fragmentation?
Yeah, thank you. Very, very possibly. And actually, I think that your point highlights something that you probably are also aware of, is that there are these spheres within the international legal community. And while they overlap to some extent, they sort of see themselves as operating separately, even though they, of course, share fundamental principles. But, international criminal law is one sphere of international human rights practitioners and and so forth. And I think that the problem can sometimes be tunnel vision of a worldview and an approach to issues. And so, as far as fragmentation, I agree with you that that's very likely, and probably it already exists to a certain extent. There's so many good blogs that came out after this definition that discuss things like that. And so one of the critiques by a professor dealt with the fact that environmental crimes kind of already exist as well within the Rome Statute. Apparently this was considered before the proposal of a separate crime of ecocide, but the decision was it didn't go far enough. And it was too, it only applied in specific narrow instances. So even within the Rome statute itself, there could be conflicting cases because the environment is referred to within a different article, crimes regarding environmental damage. So it's a problem, and I'm not sure how that will be addressed. Yeah.
There's one more question which my colleague had asked, but he's not present in today's talk. This is with regard to mens rea. Now, under International Criminal Code or the Rome Statute, mens rea is one of the prerequisites, that is intention and knowledge under Article 30, the material element. Now, when it comes to ecocide, do you feel that this can be one of the hindrances in terms of enforcement or bringing ecocide into the corpus of international criminal, the mental element requirement for adducing or proving a crime? Can it be a stumbling block in the enforcement of ecocide as a crime?
Yeah, I think so. And I mentioned that in the lecture for sure, because Because in this situation too, they've caveated it as being, okay, well, there might be knowledge that the environmental destruction will occur, and then there's different ways of characterizing that destruction, but also the caveat is that it's weighed against the benefits of the development of the project, or whatever the decision making surrounded. And I say development project because the way that Ecocide was written implies that they're talking about like the creation of different types of development projects, like a mine, or another author talked about like a coal-fired power plant. So I think that it's really problematic because we know from the outset that these things are environmentally destructive, and some of them are risky, like mining is quite risky, and you can take precautions to avoid that a certain environmental damage, but often it's just such a high risk activity. Things happen that you just cannot prevent against, but the knowledge is there that you're aware these things could happen. I mean, I think the mens rea would have to be parsed out more, but I think that the problem is that you always have the argument with this proposed definition of ecocide that the benefits of the project, or whatever it is, the activity that's being pursued, far outweigh whatever damage would be caused. And I still think you could make that argument in so many locations where this statute might be attempted to be enforced. Mm-hmm.
Thank you so much.
Thank you.
Yeah. So, Arnav, so you can ask.
Yeah, thank you so much. When you were answering that, and you mentioned development projects as being one of the central things that the current definitions of ecocide are about, that reminded me, is there any conception of ecocide that would allow for bringing in military activity, or international military activity under the purview of ecocide, given that it is a highly polluting activity which causes a severe damage to and destruction to the environment?
You mean like under the current proposed definition, if we might be able to foresee an instance when military activity would be included in that?
Yeah, especially let's say like not active military situations, but the military industrial complex as a whole, like the building of weapons, the construction of weapons, the testing of weapons, and so on and so forth.
Yeah, that's again a very good question. I think that, yeah, I don't see why not. That is definitely worth looking into more, and would be an excellent topic for another person's blog. But I mean, this is where you get into like state power, because oftentimes it's those sorts of the wide scale damage caused by weapons of mass destruction or nuclear testing. They're done by more powerful countries, or countries that already have well-established militaries. And I think that if you were talking about utilizing the proposed definition of ecocide against one of those countries, you would run into the same sort of issues that I described happening right now with the investigation into Afghanistan, because now any of the U.S. military's alleged crimes that were committed in Afghanistan, or any of the other armed forces that were accused of different crimes, they are being, what was the wording? It was they're not being prioritized by the Office of the Prosecutor. And I mean, this is not the first time this has happened in a context where a powerful nation has sort of, even though the U.S. is not a party to the statute, but it doesn't mean that there couldn't be an investigation. But this is not the first time this has happened. So I would foresee similar situations when it comes to something that you described. And probably the easier target as far as military activities would be concerned would be like smaller type militias. that would be more vulnerable to being investigated, and there would be maybe more political will to go after groups like that as opposed to like the larger powers, unfortunately. But still, like, a good point, and that should be considered.
Thank you so much for that answer.
Tanish has a doubt. Tanish J. Yeah, go ahead, please. Tanish, you might go ahead.
Yeah, so over here I have two questions. Firstly, kind of related to Arunav's question, he asked whether development of military weapons can be considered as ecocide, but I don't think that it exactly can be considered, because according to Article 8 to B 4, the intentionally launching an attack in knowledge that such attack would cause permanent destruction to the environment, permanent long-term destruction to the environment, would be considered ecocide, but only if it is not proportional, right? So in that context, the development of military weapons shouldn't really be considered as ecocide.
Yeah. Oh, go ahead, Professor Alexander.
So you are responding to.
I don't know, question.
Okay.
Yeah.
Okay.
And secondly, the way I see it, there is almost no way that even if there is an ecocide, if ecocide is made the fifth crime under ICC, it would be implemented fairly. The African and the Arab nations would be affected disproportionately, because no matter what institutional changes you do, you just can't take away the right of a nation to sanction anyone, and the sanctions by more powerful countries will always be more effective rather than, say, DRC or Yemen. So, like, is there any institutional change or any way that, if even if there is a concrete law on ecocide in the future, it can be implemented fairly?
Yeah, good comments. But as far as your last question, based on the research that I've done, no. I mean, and then my general understanding of the behavior of the court and international relations. I think that the problem is within like the concept of international criminal justice is that, well, one, as I said in my lecture, like, I don't even think on the national level in many countries you see like a fair meeting out of international of criminal justice generally, but the situation at the national level is such that, you know, the state in principle is supposed to be treating individuals the same, and that, like, you violate a law and the state will come after you. There's this relationship. But I think when you talk about international criminal justice, the relationships are just so different, and it doesn't directly translate the way that we would like, maybe in theory, for it to, because this is maybe debatable, of course, but I don't think it should be debatable. I think, like, by its very nature, it is, unfortunately, any type of international criminal justice is at the mercy of power relations between states, because that's an inescapable part of international legal actors and how these institutions function. They can try very hard, and I think that the people who work within the ICC do probably their very best to avoid the pitfalls, but they cannot escape the political nature of that institution. It's I even if they have the best intentions. And so no, I don't see an instance, at least internationally, where ecocide could be meted out in any fair way, because these relationships between states just would never allow for it, at least with the system that we now have. Yeah.
Yeah. So the way I see it, even if there is an ecocide law in future, it would most probably be utopian and not at all pragmatic.
Yeah.
So, like, why even have the discussion of an ecocide law if in the best case scenario is a utopian one?
Yeah, it's frustrating. I think the benefit maybe just to try to understand, because I think like as lawyers, we should always try to see multiple sides to an argument. But I mean, these conversations have been spurred on by the very fact that ecocide has been proposed as this fifth crime, and it has people talking about how to combat these issues like climate change and environmental damage. I think the pitfall, though, is that, and the thing that I find a bit frustrating is that we still are avoiding the harder, what I consider to be more pertinent discussions on like these systems that underpin the damage that we're seeing environmentally, and the power relations, the institutional and structural inequality, and they're not really being addressed. And so in some ways I feel that a lot of these energies are ill spent in the wrong direction. That being said, though, I should mention, there's like indigenous groups and other communities in various parts of the world that are very much for criminal liability of corporate actors or even like government actors. So it's certainly not a black and white issue. Yeah.
So that means at the end of the day, the success of any ecocide law would depend upon how it is implemented by the national governments.
I think so. I would think so.
Okay, thank you.
Mm-hmm.
Okay, anyone else?
I think so. Like with this, we can come to the end of the question and answer session. So, so I'd like to thank Ms. Sara for taking out like precious time from her schedule and taking out the time to interact with us. So in her address, ma'am also like raised very important points with respect to the United States and China not being a part of the ICC statute and yet being one of the two countries, some of the countries that have been the most polluting countries in the world. So that was a very pertinent point that I found in this entire meet. And apart from that, I think Ecocide has been there in the picture since 1978 when Olaf Palme from Sweden he tried to raise this issue in one of the international assemblies, but I think he was way ahead of his time. Now, when we see the effects of climate change, we understand how important it is to criminalize this crime of ecocide, and especially when there are leaders in Brazil like Jair Bolsonaro who say that the Amazon rainforest is just the business of the nation and not of the world. If we cut down trees, that's our business and that's none of the world's business. So I think this calls for immediate attention, and I think ma'am has suitably displayed that in her speech. So I'd like to really thank ma'am for such an enlightening session, and hopefully we'll get it. We'll meet someday in our campus in Calcutta if you're ever coming down to India. So yeah, I just like to thank everyone and Atul sir for his constant guidance and to all the audience members for such an interactive session and such brilliant questions. Thank you so much.
Thank you so much.
Thank you so much. And I would also like to say that we have started a newsletter wherein we plan to publish the developments in international law and ancillary areas of international law. So, ma'am, if you are writing anything on ecocide and any other issues pertaining to international law, do contribute. and we'll always be grateful in sharing the newsletter with you, ma'am, in the future. And we also plan to hold more talks in the coming days with legal new luminaries in international law. And of course, we'll send you an invite. Do attend these talks, ma'am, if you're free anytime. And we also like to invite you in person to NUJS, our campus located in the heart of Calcutta. We would like to extend our hospitality to you whenever you come to India. Do let us know. Thank you so much, ma'am, on behalf of Hilsa. And I would also like to thank Mehul Jain, who is heading the Hilsa chapter at NUJS. He has been working, I think, round the clock to organize this event. And in preparing the newsletter, and also in, coordinating the events, whatever we organize. I would also like to thank Varunavi and other members of the advisory board and all the members of the Hilsa chapter at NUJS. We hope and believe that we could organize more on international law so that we could disseminate the subject. Thank you so much. Thank you all. Thank you all for attending. Thank you so much.
Thank you so much. Hopefully it would be wonderful to visit after perhaps more travel restrictions are
Yes.
raised. Yeah, thank you.
Thank you so much. Thank you.